Hello. As you may know, in civil litigation as opposed to criminal litigation, you need to prove your cause on the balance of probabilities, as opposed to like beyond reasonable doubt in criminal cases, which means that the judge would balance your evidence and the evidence of the other party and see what is more probable, and based on that, the judge will render his or her decision. So, what do you need to prove on the balance of probabilities? When you want to sue somebody in court, or if you are sued in court, what they need to prove on the balance of probabilities to get the judgment they want. Well, first of all, the very idea is that you have to prove if you attack the other party. So, but for some specific exceptions, which, if necessary, you should discuss with your lawyer, normally the one who is claiming, the one who is in attack, that person needs to prove. So if you feel offended, if you feel defamed, for example, or if you think that your neighbor is encroaching on your land or spoiling your fence, or just making some intolerable noise that diminishes your enjoying of your property or something like that. So whenever you are not satisfied with the status quo, whenever you are going to court, the burden of proof is on you. You have to prove. So if you do not prove your cause on the balance of probability, sometimes the other party doesn't even need to prove anything, because the judge will simply see that, okay, your cause is not proven. Thank you, goodbye. But if the attacking party is bringing some plausible, convincing evidence, then the defending party might be also interested in preparing their own evidence, their own proof, to rebut the allegations and to show that, in fact, the story is quite different. So, again, what is to be proven? Most of the times, there are different situations, but most of the times when it comes to at least civil responsibility, one has to prove three things. Like first, that the other party was at fault. There are situations of strict or so-called strict liability when the fault is not needed, the very fact of damage is enough, but most of the times the other party needs to be at fault so that you just get what you claim from the other party, some compensation usually in that situation. Or if you want to force the other party to do something for you which the other party doesn't want to, you need to show that the other party is at fault. If it comes to a contract, then it's usually based on the contractual obligations. So here's the contract. This is what the other party should have done or should not have done. This is what actually happened. This is the difference. So the obligations are not fulfilled, they're not met, hence the fault. But if there was no contract, then it becomes a bit more complicated. You might need to prove that the other party was violating some regulations, municipal regulations, with respect to like noise level, for example, or so forth. That the other party was negligent in a sense that any reasonable person in a similar situation would think of that and would have avoided causing damage, but the party was so lacking thoughtfulness that as a result, so not caring, as a result, the damage was caused, or there was some like rules of industry or just accepted customary rules of industry that the other party should have taken into account, but they did not, and so forth and so forth. What I'm trying to say that proving fault is not always as easy as many people think, because it's not unusual when we think that if we feel offended or if we see damage, then there is like automatically some fault. But it's not always the case. And if there is no fault in this equation, then the judgment that you're seeking might not be within a reach. But let's say you found good evidence that the other party is at fault. Again, for details for your particular case, it would be a very good idea to consult a lawyer, because the situations are very different, and most of the time the question of fault is the question of fact, like what particular facts you can actually prove. Then there might be or might not be the check for this first one. Then this fault should directly, not like commonsensically, not like how else could it be, but directly, and that should be proven again, was causing the negative consequences, like negative outcome, which third was causing you damage. So basically that fault was directly causing damage. This direct cause is very often the problem, because if there is no witness or if there is no documentary proof that the damage you're claiming was caused only by that particular fault, not by something else that was happening at the same time or after this fault, which is always a possibility for defense, saying that something actually caused it or aggravated it after my actions or my lack of actions. For example, maybe we had a just very scandalous conversation, and that person felt bad after that, but the person left under heavy rain in a cold weather, for example, and then contracted some neural infection, and then after that has constant swings of mood, for example, which cannot be directly attributed to our scandalous conversation, but rather to this neural infection contracted under the rain, and the person was not forced to go under the rain. The person could call a taxi, for example. So if there is some interfering act between the fault and damage, then the direct cause, the idea of proving the direct cause might be in question, might be at risk. Or sometimes you cannot even really prove the direct cause, as in that famous, though maybe not absolutely real, story when somebody prayed that the restaurant is burnt to the ground because it was located in front of the church, and then eventually there was a fire and the restaurant was burnt to the ground, and the owner of the restaurant was suing the one who was praying, saying that, okay, well, your prayer caused the fire. Again, without any intention to discuss the power of a prayer here in this video, you might see that sometimes the cause might be lying within the realm of like a guess or a theory. Sometimes it is proven by some expert, like for example when it comes to some loss of potential income. Usually there should be an expert opinion that otherwise this income would have been earned, would have been like received. But again, the judge is not obliged to believe an expert. Without an expertise, it would be even harder to prove, of course, but well, even with an expertise, there is no guarantee. So the more metaphysical, the more esoteric the connection between a fault and damage, the lower the chance to win such a case. And finally, when it comes to damage, well, if there was a like monetary loss, financial loss, for example, your favorite seat was destroyed, or your favorite coat was torn apart by that person's dog, for example, or if there was a fire and the painting that was very valuable and it was your like family treasure, it was burned in the fire. If the painting was properly appraised before, then there is a possibility to prove your damage. Again, sometimes you need an expert to appraise. If there is a question of insurance, then usually the inspector, the syndic, the sinistre from the insurance company is there to actually just appraise and sometimes even go to litigation instead of you, I mean the insurance company. But let's say there was no insurance. Or, for example, if somebody's actions caused you some psychological damage and you were forced to go to some particular place and pay for it, or some kind of facility, or if you had to buy some specific medication and you, of course, kept your receipts, your invoices. Yeah, this kind of damage you can prove. Usually it's like quantifiable. But when it comes to suffering, first you have to prove suffering. For that, usually you need some statement from your doctor, from your treating doctor. But even then, it depends, because, okay, your suffering is described, but it's all subjective in the sense that there is no some meter for that. So it will be the judge's appreciation. Of course, again, you might ask for some expert opinion, but again, it's up to the judge to take it into account and to what extent or not. And when it comes to, again, the reasoning that, okay, you had some moral damage and because of that you couldn't go to some interview and get some job, for example, or to some negotiations and to get some contract, then again, it's what if as if area. So for the judge, the question is usually like, how probable was it in the first place? And what would have happened without this fault and direct cause. And if the judge is not convinced that you would otherwise get this income, get this job, get this contract, because it does not only depend on you and your mood, it depends on the other persons as well, then it might not be seen as proven. So what I'm trying to say, sometimes you can prove fault, you can prove that the impact on you was direct, but you cannot prove actual damage in quantifiable terms. And then even if you win in court, and yes, if the judge supports your cause, saying that yes, the other party was at fault, but in reality you will not receive enough money even to cover your legal expenses because you cannot prove the damage. And in such a situation, the money you spend on your lawyers is usually, there are situations, but usually they're not included into your damages. So, however significantly you feel offended, before starting litigation, before going into significant expenses when it comes to litigation, it's a good idea to analyze, even before you go to a lawyer to discuss, just to analyze first and then bring to your lawyer the facts you can get. What's your evidence? Because we are talking about what you should prove, right? What's your evidence to prove that the other party was at fault? What's your evidence that this fault directly caused the consequences? And what's your proof that these consequences were your quantifiable damage? If at the end of the day you can prove all that, then you have a good case in court, and well, then probably the judge would listen to you, though it's again never guaranteed, of course. But the better you are prepared, the better are the chances that on the balance of probabilities, the judge would see it your way. Thank you. Have a nice day.